A few months after a parent passes away while a family is still grieving, a letter sometimes arrives. It's from the state, and it informs the family that the state intends to file a claim against the home, the same home the family grew up in, to recover the cost of the parent's nursing home or long-term care. This is not a scam. It is not a mistake. It is federal law. It's called Medicaid Estate Recovery, and federal law has required every state to operate some version of it since 1993. If Medicaid paid for nursing home care, home health care, or certain other long-term services for someone 55 or older, the state is required to attempt to recover those costs from that person's estate after they pass away, and in most cases, the home is the single largest asset in that estate. Today, I'm going to explain exactly how this works, why so many families are caught completely off guard, and the specific legal strategies done in advance that can protect a home from this claim. My name is Lucian Vane. I've spent years studying elder law and the long-term care planning strategies that protect families from exactly this situation. I want to be direct about something before we go further. This is one of the most emotionally difficult topics in all of senior finance because it touches grief, family homes, and inheritance all at once. I'm going to walk through it carefully, clearly, and without exaggeration, because the reality of Medicaid estate recovery is serious enough without overstating it. Let's start with the basics. To understand Medicaid estate recovery, you need to understand how Medicaid pays for long-term care in the first place. Medicare, the federal health insurance program most seniors are familiar with, does not cover long-term nursing home care beyond a short, limited period after a hospital stay. For seniors who need extended nursing home care, the primary payer in the United States is Medicaid, a joint federal and state program that requires recipients to have limited income and limited assets to qualify. Nursing home care is extraordinarily expensive. The national average is over $9,000 a month for a private room, and significantly more in many states. Very few families can pay that out of pocket for an extended period, which is why Medicaid becomes the primary payer for the majority of long-term nursing home residents in America. Here is where Medicaid estate recovery enters the picture. Because Medicaid is a needs-based program funded by taxpayers, federal law requires states to attempt to recoup the money Medicaid spent on a recipient's long-term care, but only after that person has passed away, and only from their remaining estate. This means the recovery does not happen while the Medicaid recipient is alive. It happens afterward, against their estate. And in the vast majority of cases, the only significant asset in that estate is the family home. Every state must have an estate recovery program for nursing home and certain home and community-based services for recipients 55 and older. Some states limit recovery strictly to those services. Other states, called expanded recovery states, pursue recovery for essentially all Medicaid costs paid after age 55, including regular medical care, not just long-term care. Which category your state falls into significantly affects how much exposure your family has, and it's worth knowing which one applies to you specifically. Here is the single most important misconception I need to clear up, because it's the reason so many families are blindsided. When you apply for Medicaid to cover long-term care, your home is generally exempt from being counted as an asset for eligibility purposes, meaning you don't have to sell your home or have its value count against you to qualify for Medicaid in the first place. Most families hear this and assume it means the home is permanently protected. It is not. The home being exempt while you're alive only means Medicaid won't force you to sell it to qualify for benefits in the first place. It says nothing about what happens after you pass away. The exemption that protects your eligibility while living does not extend to protecting the asset from estate recovery after death. This is the gap that catches families off guard. A family does everything right during the Medicaid application process. They're told correctly that the home is exempt. They don't have to sell it. Their parent qualifies for nursing home coverage, and they reasonably assume the matter is settled. They never hear the second half of the sentence. The home is exempt for eligibility, but it remains part of the estate, and the estate is what gets pursued for recovery after death. Once the Medicaid recipient passes away, the state's claim attaches to whatever is left in their probate estate, And in most cases, if the home was still in the deceased person's name, it is part of that estate and subject to the claim. This is exactly why planning has to happen before the need for long-term care arises, or at minimum, well before the Medicaid recipient passes away. Once someone has passed and the estate is in probate, the planning window for protecting the home has already closed. This brings us to the single most important concept in all of Medicaid long-term care planning, the 5-year look-back period. When someone applies for Medicaid to cover long-term care, the state reviews the previous 5 years of that person's financial transactions, every transfer, every gift, every change in how assets were titled. This is the look-back period. If the state finds that assets were transferred, including the home to someone else for less than fair value during those 5 years specifically to help the person qualify for Medicaid, it can impose a penalty period. During that penalty period, the person is ineligible for Medicaid coverage of their nursing home care, even though they've already given away the asset. Here is why this matters so much for home protection specifically. If a family waits until a parent is already in declining health and close to needing nursing home care, and then quickly transfers the home to the children to protect it from estate recovery, that transfer falls within the 5-year look-back window and triggers a penalty period instead of protecting anything. The penalty period is calculated based on the value of the transferred asset divided by the average monthly cost of nursing home care in that state. A home transferred for $300,000 in a state where nursing home care averages $10,000 a month could create a 30-month penalty period, meaning the family would need to pay for 30 months of nursing home care entirely out of pocket before Medicaid coverage begins. This is exactly why the planning strategies I'm about to cover, irrevocable trusts and ladybird deeds, and have to be done well in advance, ideally 5 or more years before nursing home care is anticipated. Planning done at the last minute, in a moment of crisis, often does more harm than good. This is also why I want to be honest with you. If a parent is already in a nursing home or imminently entering one, many of the strategies in this video may have limited application due to the look-back period. But there are still protections worth understanding, including ones that apply regardless of timing, which I'll cover in a few minutes. Before I cover the proactive planning strategies, I want to walk through the protections and exemptions that already exist in the law right now, because these apply even to families who didn't plan in advance, and many families never ask about them. Undue hardship waivers. Every state's estate recovery program is required to have an undue hardship waiver process. If enforcing the recovery claim would cause significant hardship to surviving family members, for example, if an heir would become homeless, or if the home is the only significant family asset and selling it would leave a low-income heir without housing, the state can waive or reduce the claim. The specific criteria vary significantly by state, and the waiver is not automatic. The family must apply for it and provide documentation of the hardship. Most families never know this option exists and simply assume the claim must be paid in full. Income-producing family farms and businesses. Some states have specific hardship protections for family farms or small businesses that provide the primary income for surviving family members, recognizing that forced recovery could eliminate a family's livelihood, not just an asset. Property value thresholds. Some states will not pursue recovery if the value of the estate falls below a certain threshold, since the administrative cost of pursuing a small estate may exceed what the state would actually recover. Action step. If your family is facing a recovery claim, or anticipates one, contact a local elder law attorney or your state's Medicaid office and ask specifically, does this state have an undue hardship waiver process, and what documentation is required to apply? This single question, asked early, can significantly change the outcome. Now let's talk about the proactive planning strategies, done well in advance, that can protect a home from estate recovery. The first and most powerful is an irrevocable trust. I want to explain this in plain language because trust terminology often makes this sound far more complicated than the core concept actually is. When you place your home into an irrevocable trust, you transfer legal ownership of the home from yourself to the trust. You typically retain the right to live in the home for the rest of your life, but you no longer legally own it. The trust does, and it's managed according to instructions you set up in advance, usually for the benefit of your children or other heirs. Because the home is no longer legally yours, it belongs to the trust. It is not part of your estate when you pass away, and Medicaid Estate Recovery can only pursue assets that are part of your estate. If the home is properly titled in an irrevocable trust well before the 5-year look-back period, it is protected from the recovery claim. Here is the critical word in everything I just said: irrevocable. Once the home is placed in this type of trust, you generally cannot take it back, sell it freely on your own, or change your mind later. This is precisely what makes it effective for Medicaid planning. The home is genuinely legally out of your control and out of your estate. But it also means this decision should never be made lightly or without full understanding of the permanence involved. This is exactly why irrevocable trusts must be set up well before they're needed, typically advised at least 5 years in advance, and why working with a qualified elder law attorney, not a general practice attorney or an online template, is essential. The rules vary by state, and getting the structure wrong can create unintended tax consequences or fail to provide the protection you're seeking. The second strategy is one that almost no one outside of elder law circles has ever heard of, and it's available in a number of states, though not all. It's called a Lady Bird deed, formerly known as an enhanced life estate deed. Here's how it works and why it's so useful for this specific situation. A Lady Bird deed allows you to transfer your home to your children or other beneficiaries, but you retain complete control over the property during your lifetime. You can live in it, sell it, mortgage it, or even change your mind and name different beneficiaries, all without needing anyone's permission, including the people named in the deed. When you pass away, the home automatically transfers to your named beneficiaries outside of probate, without ever having been a completed gift during your lifetime. And because you retained full control the entire time, the transfer doesn't count as a disqualifying gift for Medicaid look-back purposes. This is the key advantage of a Lady Bird deed compared to a standard deed transfer to children. A regular deed transfer during your lifetime does count as a gift for Medicaid look-back purposes and can trigger a penalty period. A Lady Bird deed, because you retain full control until death, generally does not. The home avoids probate, transfers directly to your chosen beneficiaries upon death, and because it bypasses probate entirely, it's also generally protected from Medicaid estate recovery in states that limit recovery to the probate estate. The most important caveat: Lady Bird deeds are not recognized in every state. They are commonly used in states like Texas, Florida, Michigan, and a handful of others, but not nationally available. You need to confirm with an elder law attorney whether this tool is recognized and effective in your specific state. There are 2 specific protections written directly into federal law that apply regardless of advance planning, and every family should know about both of these. Spousal protection. Federal law prohibits states from pursuing estate recovery against a home while the Medicaid recipient's surviving spouse is still alive. This protection exists automatically. It does not require any advance planning, any trust, or any deed transfer. If one spouse needed nursing home care covered by Medicaid and passed away, the state cannot force the surviving spouse out of the home or place a claim against it while that spouse is living. It's important to understand this protection is a delay, not necessarily a permanent shield. Many states can still pursue recovery from the home after the surviving spouse later passes away, unless additional planning like a trust or Lady Bird deed has been put in place during that window. Caregiver child exemption. Federal law also includes a specific exemption for an adult child who lived in the parent's home and provided care that allowed the parent to avoid or delay nursing home placement for at least 2 years before the parent entered a facility. If that caregiver child can document this care, the home may be transferred to them without triggering a Medicaid penalty, and it may also be protected from estate recovery. This exemption requires documentation, ideally contemporaneous records, doctor's notes confirming the level of care needed, and clear evidence of residency. So if this situation applies to your family, start gathering and organizing that documentation now rather than trying to reconstruct it later. If a recovery claim has already arrived for your family, here is what to do. First, do not ignore the deadline on the notice. Most states give a limited window, often 30 to 90 days, to respond or request a hardship waiver. Missing that deadline can forfeit your right to contest the claim. Second, contact an elder law attorney immediately. Many offer free or low-cost initial consultations specifically for estate recovery matters, and the deadlines involved make speed important. Third, ask specifically about the hardship waiver process we discussed earlier, and gather any documentation that supports your case. Income levels of heirs, whether the home is their primary and only residence, and any caregiver-child documentation, if applicable. Here is your complete action list. 1. Find out whether your state has basic or expanded Medicaid Estate Recovery, since this significantly affects your family's exposure. 2. If long-term care isn't needed yet, talk to a qualified elder law attorney now about irrevocable trusts. The 5-year look-back period means early planning matters enormously. 3. Ask an elder law attorney whether your state recognizes ladybird deeds and whether one makes sense for your situation. 4. Remember that spousal protection is automatic. A surviving spouse cannot be forced out of the home or have a claim filed while they're alive. 5. If you're an adult child who has been caring for a parent in their home, start documenting that care now. It may qualify you for the caregiver-child exemption later. 6. If a recovery claim has already arrived, respond before the deadline. Contact an elder law attorney immediately and ask specifically about the hardship waiver process. This is one of the most consequential financial conversations a family can have, and it's also one of the most avoided, simply because it touches mortality and money in the same breath. But the families who have this conversation early, who plan years in advance rather than in a moment of crisis, are the ones who protect what they've worked their whole lives to build. If this video helped you, subscribe. Every week I cover the legal and financial protections that families need to understand, clearly, honestly, and before it's too late to use them. If you have aging parents, or if you are a parent thinking about your own long-term care, share this with your family. This is a conversation worth having around the kitchen table, not in a letter that arrives after it's too late to change anything. I'll see you in the next one.